started discussion about possession, and I don't know how much you were listening to me because you were much concerned about the next mid exam, and tomorrow also you have. Regarding possession, we discussed about what constitutes possession by way of definition. We discussed what constitutes possession. So what did you say regarding the definition of possession or what constitutes possession? Very important element is the physical control and then the intention to control the and we also discussed the different theories regarding these two elements, what different theories says about this element is, and we say that most of the theories, whether Sabinist theory or Jerin's theory or the realist theory, all of them agrees on the physical control. And what do they mean by physical control is not an immediate possession, or it's not an immediate physical control, or it's not the proximity with the thing. The thing can be far away from somebody else. What do you mean by physical control is the power that the person exercises in relation to the thing. The power that the person exercises. Is it the responsible person, okay, for the administration of the thing, for the management of the thing, for the preservation of the thing, and for the use of the thing? Is he a person who is responsible for all these authorities? That is what we mean by physical control that a person has over the thing. And we say that in some cases, this physical control by itself is not sufficient to have possession. We need another more element. The next element or the second element is an intention to control. And regarding an intention to control, different theories have different perspectives. For example, subjective theory says that the intention to control should be the intention to control for oneself, not for other people, okay? Not on behalf of others. So the intention to control for subjective theory or for Savini, the intention to control is the intention to control the thing as an owner. So it is very strict element management for subjective theory. An intention to control is an intention only which the owner can have management. Nobody else can have an intention to control for himself after the owner. ባለቤት ብቻ ነው ይሄ ንብረት የራሴ ነው ብሎ ንብረቱን በእጁ አድርጎ የሚቆጣጠረው ባለቤት ብቻ ነው። ምክንያቱም የኔ ማለት የሚችል ሌላ ሰው የለም። Nobody else can claim that the thing belongs to him except the owner. So intention to control is equal to the owner for subjective theory. But others say that this is very much strict and we are going to avoid a lot of people who may have different forms of interest on the same thing. As you have been considering, the owner has an interest. Somebody who received the thing as a usufructuary has an interest, a lessee has an interest, and there are also others who may have interest in the same thing at the same time. So if you just focus on the owner as the only person who can have an intention to control, you are excluding all others. And these all other people will not be in a position to protect their right unless they are considered as possessors. Okay? The usufructuary, for example, cannot bring action to court unless he is considered as a possessor of the thing. Okay? If a given house is given in usufruct to Mr. U for 10 years, if neighbors, okay, if neighbors interferes in the use of the house, if somebody else, okay, uses force to dispossess him of the house, he can't bring legal action to restore back his possession unless from the beginning he is considered as the possessor. Okay? ተከራይ ፖሰሰር ካልተባለ በስተቀር መብቱን ማስከበር አይችልም። ተጠቃሚዎች ባለቤት ሳይሆኑ ጥቅም ያላቸው በንብረቱ ላይ ጥቅም ያላቸው ሰዎች ፖሰሰር ካልተባሉ በስተቀር መብታቸውን ማስከበር አይችሉም ማለት ነው። So considering them as a possessors is giving them a chance to protect their right on the thing. እና subjective theory owner ብቻ ነው intention to control ሊኖረው የሚችለው ዲፌክት አለበት የሚል አርጉመንት አንስቶ objective theory ምንድነው የሚለው? If somebody can show a good physical control over the thing, the intention to control is presumed. የሚል ነገር ነው የሚያስቀምጡት። realist theory አለ። realist theory ደግሞ it depends, okay, it depends on the circumstances. Okay? Whether we have to give priority to somebody who has physical control, or whether we have to give priority to somebody who has an intention to control for himself, or whether we have to give priority to somebody else who just have an interest on the team. Okay? Physical control ያላቸው ሰዎች ብቻ ይኖራሉ። ምንም intention to control ሳይኖራቸው just custodians ይኖራሉ። or an interest to control ያላቸው እንደ ተከራይ እንደ ተጠቃሚ ወይ ደግሞ እንደ ባለ ገንዘብ ሴኩሪቲ የወሰዱ ሰዎች እነዚህ ኢንተረስት ያላቸው ደግሞ an intention to control አላቸው። owners እንወስድ ደግሞ he has an intention to control himself. okay? የተለያዩ ሰዎች አሉና depending on the relationship. If we are talking about the relationship between a usufructuary who has an interest and an owner who has an intention to control for himself, we may give priority to the owner depending on circumstance, or even we may give priority to the usufructuary depending on circumstance. Okay? Or we may give priority to a lessee depending on the circumstance. ተከራይ መብቱን against the owner defend ማድረግ ይችላል ሲባል እንትን አይበላችሁ ግራ ይበላችሁ። ተከራይ እንደ ተከራይ ለተከራየበት ጊዜ he can defend his right even against the owner of the house ማለት ነው። okay? ለሁለት ዓመት የተከራየ ሰው በሁለት ዓመት ጊዜ ውስጥ መብቱን ኤክሰርሳይዝ ሲያደርግ ኦነሩ የተሰጠው መብት አለው because he is the owner and he has a responsibility because he has entered into a contract of lease. okay? ውልም ስለገባ ኦነርም ግዴታ ገብቷል። ግዴታ ይገባል ማለት ነው። በየጊዜው እየመጣ ላይረብሽ ቤቴ ነው ብሎ እንደፈለገ ይሆናል ላይ ግዴታ ገብቷል። is under contract. ስለዚህ there are circumstances where we give priority to the lessee as a possessor. okay? ለዚህም ነው ባለፈው ለምሳሌ ዝም ብላችሁ 2896 ጀምሮ ያሉት ኦኬ 29 10 ምናምን አካባቢ 10 11 12 አካባቢ ያሉት ስታረቁ ታያላችሁ። ተከራይ against the owner possessor ተብሎ መብቱ ሊከበርለት ይችላል። አቁም የሚል ድርጊት ሊባል ይችላል። the owner of the house ማለት while enforcing the contract of lease we consider the lessee as a possessor. okay? So it's difficult just to consider somebody because he has an intention to control or somebody because he has a physical control ብለን ካሁኑ መለያየት አይቻልም። The circumstance has to decide. Okay? The circumstance that we are dealing with has to decide. Okay? We can't just provide for some theories. የሚል ነገር ነው realist theory የሚያስቀምጠው። We have also considered some provisions in relation to this. What is the position of our law የሚለው our law also seems to take some good pointers from subjective theory and some good pointers from objective theory. So it depends. የሚል ነገር ለምሳሌ we have been considering that we have considered 1140, 1141, 1142. okay? in the way they indicate what do we consider. okay? What do we consider in order to entitle somebody to the right of possession, or in order to give somebody the title of a possessor? What do we take into consideration? We say the definition provides about actual control. So there are situations where we focus on the actual control because the definition talks about the actual control which a person exercises over the team. And this actual control may be exercised by the person himself, or it may be exercised through another person. So the intermediary, another person, the mere holder, who may not be a possessor, but who is having actual control, and the actual control he is exercising on the thing is on behalf of me. So it is my actual control, but I am not exercising the actual control. I give it to somebody else because I want to go abroad, for example, or I want to go to somewhere, some other place, or some other business. So I give some of my belongings to somebody else. He is having a physical control. I am away, but I am still a possessor. He is exercising the actual control on behalf of me. So, but there are situations. አሁን ባወራነው 1141 ስናነብ አንድ ሰው አክቹዋል ኮንትሮሉን በራሱ ኤክሰርሳይዝ ሊያደርግ ይችላል። ወይ ደግሞ አክቹዋል ኮንትሮል በሌላ ሰው እጅ ሊሆን ይችላል የሚል ነገር ነው። ይሄም ማለት ለምሳሌ አሁን እንዳልኩት ለሁለት ወር አንድ ስልጠና አለ አዲስ አበባ ሄዳለሁ። ንብረቶችን የሆነ ሰው ሰጥቼ ሄዳለሁ። ኦኬ now I am away but I am still a possessor, so there is a mere holder. I am exercising my actual control over the thing through Mr. C, who is a custodian. Okay, the custodian ማለት ነው። አንድ ሰው ማታ ገብቶ ንብረቶቹን ሰርቆ በእጁ ቢያደርግ እና ያ ሰውዬ የኔን ንብረት አደራ ሰጥቼው ሄጃለሁና ለማስመለስ ፖሊስ ጣቢያ ቢሄድ ለማስመለስ ማመልከቻ ጽፎ ፖሊስ ጣቢያ ቢሄድ ለማስመዝገብ የሆነ ቦታ ቢሄድ ከዛ ሰውዬ ጋር ክርክር ውስጥ ቢገባ is he going to be considered as a possessor or no, because he is just controlling on behalf of me, he is not a possessor and he can't defend the property? What do you say, for example? Actual control not for himself. It is my actual control. I am away. I am exercising my actual control indirectly through C, the custodian. I am away. So the actual control he is exercising is my actual control. But something happens to the king while he is in control of the king, as I have said. And now there is a confrontation between the person who was forcefully taken, the king, and the mere holder, the custodian, as described under level 47, sub-article 1 or so. So yeah, mere holder not ተብሏል አይደለም እንዴ? He is controlling the thing on behalf of me አይደለም? ለኔ ብሎ ነው ንብረቱን የያዘው እና he is a mere holder. But he doesn't have an intention to control for himself, or he doesn't have any interest in any personal interest in controlling the thing. He is controlling for the benefit of me. So, are you going, when you compare this person and the person who took the robber, okay? The person who took the thing is forcefully. Whom are you going to give priority? You are going to say, no, both of you are not in a position to be considered as a possessor, and let Gaddisa come back after 2 months and claim his property. What are you going to say? 11:48 ጋር ስንሄድ ምንድን ነው የምለው? 11:48 ምንድን ነው የምለው? The situation where we can even protect a mere holder considering him as a possessor, አይደለም? He can use force, he can bring legal action. Mere holder, a custodian. So he is not actually a possessor in accordance with the definition, or in accordance with what we can read out from 1141. In accordance with 1141, this person is exercising my possession on behalf of me. Yenen possession no yen actual control no exercise እያደረገ ያለ 11:49. In the same person, if you read another article and if you create the case like this one, you can consider him as a possessor. When you compare him in relationship to somebody else who doesn't have even physical control, or who acquired physical control on the thing unlawfully. Okay. ህገወጥ በሆነ መልኩ ከሱ የሚወስድን ሰው the robber ከሱ ጋር ስናወዳድረው we will consider this person as a possessor. We have another reason, we have another interest ማለት ነው. For the preservation of the thing, he is the best person. For the preservation of the thing. The thing has economic value not only for me as the owner, the thing has economic value not only for me, for the society. Okay? አይደለም እንዴ? አንድ ንብረት ጠቃሚነቱ ኢኮኖሚክ ቫልዩ ለኔ ብቻ ነው አዎ ሚኒባሱን እኔ ብቻ ነኝ የሚሄድበት ሰው አይሳፈርበትም ገንዘብ እየከፈለ just for the society in general ለማኔጅመንት ለአጠቃቀም ሲባል ነው ለግለሰቦች ሲጀመር individual right ፈጥረን ኮንትሮል የሚያደርጉት የሚጠቀሙት እንጂ most of the things have value for the community አይደለም ያን ነገር ኢኮኖሚ የሚባለው ከየት መጥቶ ነው ለምሳሌ አየር ላይ መጥቶ ነው ነገር ኢኮኖሚ የሚባለው አይደለም እንዴ ሁላችንም ያዝነው ወይ ሁላችንም ያላዝነው ሌሎች ከያዙት ጋር
ተደምሮ እኮ ነው ኢኮኖሚ ምናምን የሀገር ኢኮኖሚ የሚባለው እንጂ እኮ ወይ የመንግስት መስሪያ ቤት የተቀመጠ ወይ ደግሞ አዲስ አበባ የጠቅላይ ሚኒስትር ቢሮ የተቀመጠ ነገር ብቻ ታስቦ አይደለም። በየግለሰቦች እጅ ያሉ ነገሮች ናቸው ተደማምረው የሀገር ኢኮኖሚ ናሽናል ምናምን ግሮስ ፕሮዳክሽን ምናምን የሚባሉ ኢኮኖሚክስ ውስጥ ያሉ ብዙ ነገሮች የግለሰቦች እጅ ያሉት ነገሮች ሁሉ ተደማምረው ነው እንጂ when talking about things at individual level, yes, we talk about individual right, individual interest. But it is not possible to avoid the interest of the society in each and every single bill you have in your pocket. Anyways, so he may be in a better position to preserve the thing from any kind of damage, or he may be in a better position even to protect the interest of others like me who is not around. So we may give priority to this person and we may consider him as a possessor in some circumstances. That's about it. Then transfer of possession. We have under 1143 transfer of possession or acquisition of possession are this same thing. If you read 1143 and the following, they talk about transfer of possession. Okay? Transfer and acquisition are not much different. Okay? Transfer of possession, when you talk about transfer of possession and when you talk about acquisition of possession, they are not much different, because if there are two possessors, the original possessor and then a new possessor, if they enter into a contract of sale for something, for some movable and the seller is the original possessor, and then by the time they enter into a contract of sale and by the time the buyer, the new possessor, the buyer or the new possessor takes delivery of the thing, then the possession transfers from the seller to the buyer. At the time the seller delivers the thing to the buyer, then the buyer acquires possession. That is acquisition of possession. And delivery indicates transfer of possession from the seller to the buyer. And when you are talking from the perspective of the buyer, you talk about acquisition of possession. Okay? When you talk about the transaction, you talk about transfer of possession. So transfer of possession and the acquisition of possession is just from different angles. No, it is the same transaction or it is the same relationship. And now, possession can be transferred from transferred through different mechanisms from one person to the other person, and we talk about transfer of possession because transfer of possession indicates a lot of things. Okay, so the transfer of possession why we have to discuss about transfer of possession, because there are different consequences. Okay, consequences which results from transfer of possession. Okay, can you give me an example? What transfer of possession implies in this case, for example? ይሄ የምንቀሳቀስ ንብረት ሽያጭ ውስጥ ገቡ እነዚህ ሰዎች የሽያጭ ውል አላቸው, and then the seller delivers the buyer the thing to the buyer. So if the thing is delivered to the buyer, what do we say in accordance with 1143? Then there is transfer of possession. There is transfer of possession. So what is the effect of transfer of possession? Why are we concerned about transfer of possession? Can you think of any reason why we are concerned about transfer of possession and provide these articles talking about transfer of possession? Risks attached to the thing. The risk of damage, the risk of loss, the risk of perishing, or the risk of deterioration. All these things ማለት ነው. የመጥፋት የመውደም የመበላሸት ምናምን አደጋዎች አሉ. እነዚህ አደጋዎች ከሴለር ወደ ባየር ተላለፉ የሚባለው, we consider that the risk is transferred from the seller to a buyer when the thing is delivered. Okay? When the thing is delivered, we consider that a risk of loss or damage transfers from the buyer to the seller. Okay? The buyer from the day when the thing has been delivered to him in accordance with the provisions of the contract. When it's written for. Okay? So start. This is just an example. It's not our primary concern. So start. Sabartikil one is ittanebu. Shiya tourist. Transfers from the seller to the buyer at the time the thing is delivered in accordance with the provisions of the contract or the provisions of the civil code. So start. Sabartikil one is so transfer of possession indicates delivery is the government. Delivery indicates transfer of possession. Delivery indicates transfer of possession. So if there is transfer of possession, there is transfer of risk to the buyer, to the new possessor. From the time the possession is transferred to him onwards, it is up to the buyer. Okay, it is up to the buyer to preserve the thing, to take care of the thing, to be responsible for all the damage or deterioration to the thing. From the time the possession is transferred. And the possession is said to be transferred to the buyer from the time the thing is delivered, if we are talking about contractual relationship. If we are talking about contractual relationship. Not only this, if you read 1186, Article 1, what does it say? If there is transfer of possession, there is a presumption about transfer of what? There is a presumption about transfer of ownership. 1186 of Article 1. Transfers, when he takes possession of the thing, there is a presumption that he has taken ownership also. Ownership and transfer. So that's why we have to talk about transfer of possession. So transfer of possession takes place in the first place through delivery. Delivery of the thing. Okay? Delivery of the thing. That is the primary way through which, that is the primary mechanism through which possession is transferred. Delivery of the thing. Any transfer of possession made by virtue of contract shall be effective at the time when the thing is delivered. Okay? Delivery is the primary mechanism for transfer of possession from one person to the another person. Delivery of the thing about which we are talking in relation to possession. The possession in Minnauraletin Nagar can't then we say that there is transfer of possession. So delivery is an important event. Delivery is an important event for transfer of possession. And what do you mean by delivery? Delivery may take different forms. Okay? Delivery may take different forms. Delivery is bad. You get delivery to me chance to must that allow on each other. Okay? When you talk about delivery, delivery may not be just giving the thing to the other person. Okay? It's not. It may not be just giving the thing to the new person, to the buyer or to the new possessor. It may take different forms. And in fact, the ordinary form of delivery is actual delivery. Okay? Actual delivery. It is the ordinary form of delivery in the normal circumstance. Okay? In the day-to-day business relationship, if you go to a shop and buy something, then you take delivery, actual delivery. Immediately you pay the price and you take actual delivery of the thing. That is an ordinary form of delivery, and we call it as actual delivery. Okay? Actual delivery. So actual delivery has been indicated under Law of Sales 2274. Okay? If you read Article 2274, it says that delivery consists in handing over of the thing. Okay? Handing over of the thing to the other person together with the accessories of the thing. Okay? Together with the accessories of the thing. That's what we mean by actual delivery. Actual delivery. But there are different forms of delivery, as the law itself provides. And 1144 is talking about a little bit, okay? A different form of delivery. Delivery may not be just handing over of the thing. Delivery may not be just handing over of the thing. True or false? Delivery may not be just handing over of the thing to the other person. Testify the truthfulness of the statement by reading out 1144. Why true ሲባል? Because there is another form of delivery. Delivery is not just handing over of the thing. It may take another form. That's how you justify. Delivery may not be only the handing over of the thing. ተብሎ ሲባል true ቃል why ሲባል? Because there are other forms of delivery. Handing over of the thing is only one form of delivery, and we call it as actual delivery. And there are other forms of delivery which can still transfer a possession from one person to the other person. The best example in this case is from one person to the other person without actually handing over the thing from one person to the other person. The example in this case is
document transformation.
Giving the documents that represents the thing. Okay? The thing can stay where it is. If I receive documents which represents the thing, the law considers that I have received the thing itself. Okay? The law presumes that I have received. It is equivalent to receiving the thing. Okay? Receiving documents that represents a thing is equivalent to receiving the thing itself. Unless the contrary is proved. Okay? Unless the contrary is proved. And now, document representing the thing ሲባል ዝም ብሎ ማንኛውም ደረሰኝ ሁሉ አይደለም by the way. Okay? It should be a document of title. Okay? A document which represents the thing ሲባል ባለቤትነትን ባለመብትነትን መብትን የሚያሳዩ ዶክመንቶች ናቸው። ኦኬ? እንጂ ዝም ብሎ ማንኛውም አንድ ንብረት ዋጋው ተጠቅሶ ደረሰኝ በማንም ስም ማንም ሰው ከመሬትም አንስቶ ከዓመታት በፊት ሱቅ ውስጥ ጠፍቶ የቆየ ደረሰኝም አውጥቶ ደረሰኝ ስጠኝ ሲሉ ጽፎ የሚሰጠው አይነት ደረሰኝ አይደለም። ወይም ዶክመንት ማለት ነው። ኦኬ? Documents represents the things are documents which have been authenticated by the concerned authorities. በሚመለከታቸው አካላት እውቅና የተሰጣቸው ዶክመንቶች። ስለ መኪና ስናወራ ሊብሬ ኦኬ? ባለቤቱ የዛ መኪና ባለቤት ባለመብቱ ማን እንደሆነ የሚያሳይ ኦኬ? Bill of lading for example, bill of lading. ኦኬ? Bill of lading የሚባለው ለምሳሌ አንድ ሻጭ አንድ ገዢ ኢትዮጵያ ውስጥ ተቀምጦ ከዱባይ or from somewhere else ንብረት ያሳዝዛል። ንብረቱ የዛሬ 4 ወር ነው ገና በመርከብ ተጭኖ የሚመጣው። ከዛ ቀድሞ ግን በፕሌን ምን ይላክለታል? እቃዎቹ ዲስክራይብ ተደርጎለት ማን ነው ጫኙ ማን ነው የተሰጠው ለማን ነው መቼ ቀን ነው የሚደርሰው እቃዎቹ እያንዳንዱ ዲስክራይብ ተደርጎ ኦተንቲኬት ተደርጎ ኦኬ በሚልከው ኦርጋን ኦተንቲኬት ተደርጎ እቃው ከሚነሳበት ሀገር በሚመለከተው ኦፊሻሎች ኦተንቲኬት ተደርጎ ያ ዶክመንት ይላክለታል። ኦኬ? ገዢው ማለት ነው ኢትዮጵያ ውስጥ ተቀምጦ ያንን ዶክመንት ይዞ ንብረቱ መቼ ነው የሚመጣው? ከ4 ዓመት በኋላ ከ4 ወር በኋላ ንብረቱ ከ4 ወር በኋላ ነው የሚመጣው። ንብረቱ 4 ወር እዚህ እስከሚደርስ ድረስ ያ ዶክመንት ተይዞ ንብረቱ 10 ጊዜ ሊሸጥ ይችላል። ኦኬ? መጨረሻ ላይ 10ኛ ሰው ያንን ዶክመንት ይዞ ከሄደ ንብረቱን ጅቡቲ ሲደርስ ንብረቱ ሄዶ መረከብ የሚችለው ዶክመንቱን የያዘ ሰው ነው። because the document represents the thing, they can deal with the document ማለት ነው። የመጨረሻ ሰው ሄዶ መረከበው ሰውዬ ጋር ሲደርስ ከተገዛበት ዋጋ እጥፍ ሆኖ ሊሆን ይችላል ንብረቱ ዋጋው እየተሸጠ ማለት ነው። That's what we mean by documents which represents the thing. It's not every receipt ማለት ነው። Every receipt that people give us when we go to any shop. So documents representing the thing የሚለው check it. So possession may be transferred to a new possessor by the delivery of the documents representing the thing and enabling him to dispose thereof. Okay? ንብረቱን የሚመለከት ዶክመንት እና ለሌላ ሰው አሳልፎ ለመሸጥ ለሌላ ሰው አሳልፎ ለመስጠት የሚያስችሉት ዶክመንቶች መሆን አለባቸው ነው የምለው። ኦኬ enabling him to dispose thereof ነው። It should be a document which entitles somebody to dispose or to transfer the thing. Not every receipt. So that may constitute delivery. Okay? Receiving the document may be equivalent to receiving the thing. So we don't need an actual handing over of the thing in all circumstances. Okay? In all circumstances. In some circumstances it may not be even practicable. Okay? ሙሉ መኪና እቃ ከሆነ ዶክመንት በመስጠት ነው ዴሊቨር ተደረገ የሚባለው ወይ ደግሞ መኪና ላይ በመጫን ነው ዴሊቨር ተደረገ የሚባለው እንጂ ሱቅ ሄደን አንድ ሳሙና ስንገዛ እንካ ተብሎ እንደሚሰጠን ነገር handing over of the thing ሁሉም ኤክስፔክት ማድረግ የለብንም። የሚሸጠው እቃ 10 መኪና እቃ ሊሆን ይችላል። Okay? It may be bulky, it may be so huge. Handing over of the thing may not be practical even in some circumstances. So that's why the law considers handing over of a document as one of the forms through which possession may be transferred. Sometimes handing over of the thing may not be practicable. Okay? But Article 2 is very important. 1144 mark. If a dispute arises between the buyer in Ethiopia and the person who has actual control over the thing, okay? ሻጩ ወይ ደግሞ የመርከቡ ባለቤት ንብረቱ በእጁ ነው ያለውና if or የመኪና ሽያጭ ብትወስዱ if you take another example for this የመኪና ሽያጭ ብትወስዱ መኪናውን they enter into seller and the buyer still they enter into a contract of sale for a car and then the buyer pays half. Okay? The buyer pays half. አሁን መክፈል የሚችለው ግማሹን ነው 300,000 ብሩን ብቻ ነው 300,000 ብሩን ከ6 ወር በኋላ then 300,000 ብሩ እስከሚሰጠው ድረስ ባየሩ ግማሽ ስለከፈለ ደግሞ ዶክመንት he receives the document of title. Okay? He receives the document of title. But there is no change of the name, change of the title. The seller keeps the title over the thing ማለት ነው። ባለቤትነቱ በሱ ስም እንደተመዘገበ ይቆያል። ሴለሩ ንብረቱ በሱ እጅ ይቆያል። ንብረቱ በሱ እጅ ይቆያል። ይሄ ባየር ግን ዶክመንት ይዟል። መኪናውን ሪፕሬዘንት የሚያደርግ ዶክመንት ይዟል። ሴለሩ ደግሞ ንብረቱን ይዟል። ሴለሩ ንብረቱን የያዘው ገና ከ3 4 6 ወር በኋላ የሚከፈለው ግማሽ ዋጋ አለ። ባየሩ ዶክመንት የተሰጠው ደግሞ ኦልሬዲ ግማሽ ከፍሏል። ግማሽ ከፍሎ ንብረቱን ሪሲቭ ለማድረግ he is expecting the 6 months to come. So both of them have interests. One keeps the physical control of the thing and the other keeps the document which represents the thing. If a dispute arises between the two individuals whom we consider as a possessor, if a dispute arises, I'm talking of who is going to be considered as a possessor. Okay? ማን ነው የማን መብት ነው የሚቀድመው or ባለቤቱ ማን ነው ምናምን አይደለም. Just as a possessor. Whom we give priority as a possessor. It is the person who has actual control of the thing. አይደለም እንዴ? ሰባርተግልቱ ያንን ነው ብለው. Because our definition under 1140 is possessor is a person who has actual control. Because the definition. So the በእጁ ያደረገው ሰው ሁሉም ቅድሚያ ይሰጣል. That's what our article talks. Where a dispute arises between a holder of a document and the person who has actual possession of the thing, the latter shall be preferred unless his bad faith can be proved. Okay? ንብረቱን የያዘ ሰው ምንም መብት ምንም ጥቅም ሳይኖረው እንደዚሁ because of his bad faith የያዘው ከሆነ ያንን ፕሩፍ ማድረግ የሚቻል ከሆነ he doesn't have any interest, he is just trying not to enforce the contract. Okay? ኮንትራቱን ላለመፈጸም ብቻ ብሎ እንደዚሁ ጠማማ ሰው ስለሆነ ነው ወይ ደግሞ ፈቃደኛ ስላልሆነ ነው ውሉን ለመፈጸም ፈቃደኛ ስላልሆነ ብቻ ነው ያንን ንብረት ይዞ አለቅ ያለው እንጂ ምንም እኔ ጋር የከራው ክፍያም የለውም ሙሉን ከፍያለሁ. ኦኬ? አስፈላጊውን ሁሉ ፈጽሜያለሁ እሱ እንደዚሁ እኔ ያልኩት ካልሆነ የሚል ሰው ስለሆነ ነው ንብረቱን የያዘው ይልቀቅልኝ ተብሎ ከተባለ even if he has the physical control of the car or the thing he may not be presumed as a possessor. Okay, if the other party, who is the other party? The party who has the possession of the document. Okay, the party who has the possession of the document, if he can prove that the other party who has the possession of the thing is in bad faith, then the priority may be given to the person who has the possession of the document. Document የያዘው ሰው ቅድሚያ ሊሰጠው ይችላል የሚለው unless his bad faith can be proved ነው የሚለው. Okay, so if the bad faith of the person who has a physical control can be proved, then we give priority to a person who has a possession of the document. Otherwise, in the normal circumstance, if a dispute arises between somebody who has the possession of the document and somebody who has the possession of the thing, we give priority to the person who has the possession of the thing, because our definition primarily depends on the person who has an actual control over the thing. That's what 1144 is talking about. Then there is still another form of delivery which can transfer possession. 1145 constituent possessorium is about constructive possession. Okay, constituent possessorium is about constructive possession, and I think we have discussed about this last time. When a seller and the buyer enters into contract of sale, the nature of the thing, okay, the nature of the thing decides. For 1145 to be relevant, we first start from the nature of the thing. Things of generic nature, no, things of generic nature. Okay? ተመሳሳይ በጋራ ሲል የምንጠራው ጤፍ፣ ስኳር፣ ቡና ምናምን እያን የምንላቸው ነገሮች በመስፈሪያ በኪሎ በኩንታል በምናምን በቶን ብቻ የምንለኩ ነገሮች ከሆኑ ሽያጩ ስለዛ ከሆነ ለዚህ ገዢ የተለየው okay, thus part of the thing which has been assigned to the buyer should be individualized and should be specifically assigned to the buyer. ባለፈው ነው ማለት ነው ለብቻ አስቀምጦለት ምልክት አድርጎበት he assigns specifically those things to the buyer and declares that the thing has been sold to the buyer and the possession has been transferred to the buyer ብሎ ዲክላር ካደረገበት ጊዜ ጀምሮ የነዛ ንብረቶች ፖሰሰር ማን ተብሎ ይታሰባል ነው አንብቦ 1145 አንብባችሁ as possessor from the time the seller declares that the thing has been delivered to the buyer. So declaration shows the intention to transfer possession to the buyer ማለት ነው ለባየሩ ለገዢው ፖሴሽኑን ለማስተላለፍ ፈቃደኛ መሆኑን ይገልጻል ማለት ነው የሱ ነው እዚህ ከዚህ መጣ ይወሰድ ብሎ ወይ ደግሞ ስልክ ደውሎ ለራሱ ይሄው ለብቻ አስቀምጬልሃለሁ ስትመጣ እንትናን አናግረው ውሰድ. This is the declaration and it shows the intention of the seller to transfer possession to the new buyer. So from that time onwards, we consider that the possession has been transferred to the buyer and it is the buyer who is considered as a possessor. And now possession transfer አረገ ማለት ደግሞ ownershipን transfer አረገ ባየሩ ነው owner የሚባለው ማለት ነው. In other words ወደ ቅድሙም ስነት ለምሳሌ ዛም ያ መጋዘን ከዚህ በሚቀጥለው ቀን ቢቃጠልና ንብረቱ ቢወድም ባየር ካልከፈለም ይከፍላል ከከፈለም ከስሮ ይቀራል ማለት ነው ሌላ ንብረት ሲተኛ ይቻላል because the thing has been delivered constructively the possession has been transferred ግን ንብረቱን እንደዛ ለይቶ ሳያስቀምጥ አንድ ላይ እንዳሉ ችግር ቢደርስ the buyer is not going to be responsible. ከፍሎም ከሆነ ሌላ ንብረት ሲተኝ ወይ ደግሞ ገንዘቡን መልስልኝ ይችላል ካልከፈለም አልከፍልም ማለት ይችላል because the thing has not been individualized and assigned to the buyer. 1145 ነው ያወራን ያለ ነው ንብረቱ ሴለሩ ጋር ነው ያለው ኦኬ ንብረቱን ባየሩ አልወሰደም thing is still with the seller But the intention to control has been transferred to the buyer, and now the buyer is considered as the owner of the thing. Okay? So the seller is no more the owner of the thing. The law presumes that it is the buyer who is the owner of the thing. Buyer no. ባለቤት ተብሎ የሚገመተው በህግ 1186 አርቲክል 1 together with 1145 article 1. It is the buyer who is the owner of the thing. እና ሌሎች ከሴለሩ መብት የሚጠይቁ ሰዎች እንኳን ቢኖሩ ወደዛ ንብረት መምጣት አይችሉም የሚል ነገር ነው የሚያሳየው። ኦኬ ይሄ ሴለር ለምሳሌ ይሄን በፍርድ ቤት ተፈርዶበት ኦር መክፈል የነበረበት ዕዳ ሳይከፍል የቀረ ሆኖ ንብረቱን ለማስያዝ ቢመጣ የዚህ ገዢ ንብረቶች ገዢው ንብረቶቹን ከመውሰዱ በፊት ኦኬ ገዢው ገና የዛሬ አንድ ሳምንት ነው የምትወስደው ብለናል። ባየር በዚህ ሴለሩ በዚህ መሃል ማለት ነው ሴለሩ በዚህ መሃል ተፈርዶበታል 500 ሺህ ብር ያልከፈለው አለ ወይ መክፈል አለበት ተብሎ ንብረቱን አታች ለማስደረግ ይመጣል። ኦኬ የፍርድ ባለመብቱ ንብረቶቹን አታች ለማስደረግ ይመጣል። ንብረቶቹ እየተቆጠሩ እየተመዘገቡ ነው እና ቁጥራቸውን የምትመዘግቡ ሰዎች ብትሆኑ ለዚህ ባየር ለብቻ ስፔሲፊካሊ አሳይን ተደርጎ የተቀመጡትንና ባየሩ ገና የዛሬ ሳምንት መጥቶ የሚወስደውን ዕቃ ትቆጥራላችሁ?
አይቆጠሩም።
ለምንድን ነው የማይቆጠረው? የምትቆጥሩ እስኪ ቆጣሪዎች የምትቆጥሩ እስኪ ምክንያቱም ለባየሩ እኮ ተላልፏል። ኢንቴንሽን ዲክላር አድርጓል፣ ስፔሲፋይ አድርጓል፣ ለብቻ አስቀምጦለታል። የ1145 አርቲክል 1 ኤሌመንት ተሟልቷል ማለት ነው አይደል? የ1145 አርቲክል 1 ኤሌመንት ከተሟላ ምን ማለት ነው? Possession has been transferred አይደለም እንዴ? Who is having constructive possession? The buyer is having constructive possession. That is why the title is constitutive possessory ብሎ የሚያስቀምጠው constructive possession ማለት ነው። Who is having constructive possession? The buyer is having constructive possession. And the thing is not considered as a thing belonging to the seller after the declaration of intention and assignment of the thing to the seller ማለት ነው, to the buyer. አሁን ይሄን ያልኩት ሰብ አርቲክል 2 ላይ ያለውን ነገር ለነገረኝ ሰው እዚቹ የ5 ማርክ ቼክ ይፈርምለታለሁ። ለሴለር ነው እያወራን ያለነው። ይሄ ሴለር ባንክራፕት ተባለ ማለት ካሉት ንብረቶች ዕዳዎቹ ይበልጣሉ ማለት ነው። ኦኬ ባንክራፕት የሚባለው ሰው ካሉት it is a person whose debt is greater than his asset ማለት ነው ባንክራፕት። ኢኮኖሚክስ ላይ አለ ምን ላይ ያለው ብቻ የሆነ ነገር ላይ አለ ባንክራፕሲ እኔ ድሮ ቡክኪፒንግ የሚባል ትምህርት ነበረ ድሮ። ባንክራፕት የሚባለው አንድ ሰው ካሉት ንብረቶችና ካሉት አሰቶች ዕዳዎቹ ከበለጡበት ያሉትን አሰቶች ያሉትን ንብረቶች ለመከፋፈል ክሬዲተሮቹ ምን ሊሉ ይችላሉ? በቃ ባንክራፕት ተብሎ የከሰረ ሰው ዕዳውን መክፈል ያልቻለ ሰው ወይ ደግሞ የማይችል ሰው ዕዳዎቹ ከንብረቶቹ የበለጡበት ሰው ተብሎ ዲክላር ይደረግልና ንብረቶቹ በሙሉ ተይዞ ይሸጡና የሚደርሰን ያህል እንከፋፈል የሚባልበት ነው ባንክራፕሲ። ኦኬ እና የዛሬ 6 ዓመት የዛሬ 10 ዓመት የዛሬ 5 ዓመት የሚከፈሉ ዕዳዎችም እዛኔ አይጠበቅም። ኢሚዲየትሊ ዛሬውኑ ሁሉም ሰው ምክንያቱም ዕዳዎቹ ከንብረቶቹ ስለበለጡ ዛሬውኑ ንብረቶቹ ተቆጥሮ ተሽጦ ከሚገኘው ፕሮፖርሽናል አይበቃቸውም። ያውቃሉ 10 ክሬዲተሮች ናቸው የሚጠይቁት 1 ሚሊዮን ብር ነው። ንብረቶቹ ደግሞ ሲደመሩ 700 ሺህ ብር ነው። ስለዚህ አይበቃም እና ያው የምንከስረውን ያህል እንከስራለን፣ ፕሮፖርሽናል እንከፋፈል። ባንክራፕት ተባለ ማለት ነው። ስለዚህ ባንክራፕት የተባለ ሰው ከሆነ ሴለሩ ባንክራፕት የተባለ ሰው ንብረቱን መሸጥ አይችልም። If he is declared bankrupt, he can't transfer any of his assets, he can't enter into a valid contract of sale, he can't dispose any of his properties. ስለዚህ ይሄ ሲቹዌሽን ባንክራፕት ለተባለ ሴለር አይሰራም። ንብረቱ እሱ እጅ እያለ አውቆ ንብረቱን ከክሬዲተሮቹ ለማሸጥ ብቻ ለሚስተር ባየር ሸጫለሁ አስተላልፌያለሁ የሱ ሆኗል የሚል ነገር ንብረቱ በሱ እጅ እስካለ ድረስ አይሰራም ነው። ኦኬ ንብረቱን ለማሸሽ ብሎ እውነት ሳይሸጡ okay without actually entering into a contract of sale while still the thing is under possession and actual control of the seller if they enter into a simulated contract whereby they claim that the possession has been transferred to the buyer እኛ 1145 አርቲክል 1 ላይ ለሪዝነብል ቢዝነስ ትራንዛክሽን ብለን ያስቀመጥነው ኦኬ in the normal circumstance ብለን ያስቀመጥነው ነገር ምንም ንብረቱ በሴለር እጅ ቢኖርም እንኳን ወደ ባየር ተላልፏል ባለቤትነቱ ባለመብትነቱ ወደ ባየር ተላልፏል ብለን ልናስብ እንችላለን ባየር ባለቤት ሆኗል ብለን ማሰብ እንችላለን ብለን እኛ አርቲክል 1 ላይ ያስቀመጥነው unreasonably unfairly መጠቀም አይቻልም ባንክራፕት የተባለ ሴለር መሸጥ አይችልምና ውሸቱን ከዚህ ሰውዬ ዘመዱ ነው ንብረቱን ለማሸሽ ተብሎ ኦኬ ንብረቱን ለመውሰድ ጊዜ አላገኘም አጋጣሚ አልተገኘም ከወዲው ሽጫለሁ ለዚህ እኮ ሽጫለሁ ዲክላር I have sold these things to Mr. B and I have declared that the possession has been transferred to the buyer የሚል ወሬ አይሰራም ኦኬ because the law wants to protect the creditors the law wants to protect the creditors ማለት ነው that's what article 2 is talking about. Then you have defects in possession. Okay, defects in possession. Defects in possession. That is 1146. And defects in the possession. In order to understand the defects in possession, you start from the elements that we take into consideration in order to give somebody a title of a possessor. Okay? We said actual control, we need to have actual control, or he needs to have an interest which shows his intention to control. So defect is a circumstance which affects one of these two elements. Okay? And so possessor የሚባለው actual control ካለውና actual control ለምን እንዳለው interest ማየት ከቻለ okay it is when he can show that he has an interest in controlling the thing and he has an actual control which he exercise over the thing so these two elements so defect in possession is a circumstance which affects one of these two elements or both of the elements. It is a fact. It is a fact which makes us unable to identify these two elements. Okay? It is a fact or circumstance which makes us unable to identify these two elements and entitle the person to the position of the possessor. Okay? እነዚህን ሁለቱን ኤሌመንቶች አይደንቲፋይ እንዳናደርግ ወይ ደግሞ አንዱ ኤሌመንት ሚስ one of the element is missing የሚያስፈልግ circumstance okay it is a circumstance on the basis of which we conclude that one of the two elements are missing so defects in possession እና vices in possession ይባላል okay vices in possession defects in possession vices in possession because these are vicious circumstances, okay? Defects are vicious circumstances, okay? የሚያስብለን circumstance ነው defect የሚባለው or it doesn't have this it doesn't fulfill these elements የሚያስብለን circumstance ነው የመጀመሪያው ነገር ለምሳሌ ሁለቱንም ኤሌመንት ማግኘት ያለበት አንድ ሰው it is through lawful mechanism okay it is through lawful mechanism in order for somebody to have the two elements he should acquire the two elements through lawful mechanism okay an example unlawful mechanism through which a person may acquire the actual control unlawful mechanism? Or መስረቅ, by stealing the thing, or by robbing somebody else, or you get it from somewhere and keep it and hides it. Okay? ሞባይል አንድ ሰው ትልቅ ዋጋ ያለው 10,000 15,000 ብር የሚሸጥ ሞባይል አገኘና በጣም ትልቅ ዋጋ ነው። እኔ 3 አመት ነው የምቀረኝ፣ 2 አመት ነው የምቀረኝ ለመመረቅ። ከ2 አመት በኋላ እንደውም ዋጋው ይጨምራል እንጂ አይቀንስም። ስለዚህ የዛኔ ነው የምጠቀምበት ወይ ደግሞ የዛኔ ነው የሚሸጠው። አሁን ተነክቶብኝ ችግር ከሚገጥመኝ ብሎ ደብቆ ይዛል። አግኝቶ ማለት ነው፣ አልሰረቀም። ፎረዘ ለግድ መስረቅ አያስፈልግም። አግኝቶ ግን ደብቆ ነው የሚይዘው እና ከ2 አመት በኋላ ከ3 አመት በኋላ ከ5 አመት በኋላ ቢያወጣ አንዱ ኮንሲደር ማሰ ፖሰሰር ዛሬውኑ አይተን ዛሬውኑ ፖሰሰር አይባልም። 1146 ሰብ አርቲክል 1 እንደዛ ይላል። ቶሎ ብላችሁ የስ አትበሉ። 1146 ሴክሬት ፖሴሽን ይላል። ኦኬ ሴክሬት ኦር ዱቢየስ ፖሴሽን ይላል። ሴክሬት ፖሴሽን የሚባለው ሰብ አርቲክሉን ጨምራችሁ አንብቡ። ሁለት ዲፌክቶችን ነው 1146 ሰብ አርቲክል 1 ሁለት ዲፌክቶችን አስቀምጧል። ሴክሬሲ እና ዱቢየስነስ ሁለት ዲፌክቶችን አስቀምጧል። ሰብ አርቲክል a secret or dubious possession doesn't give rise to any legal right ይላል። ኦኬ አንድ ማወቅ ያለባችሁ አክቹዋል ኮንትሮል ህጋዊ እቅና ስትለው እንደ ፖሰሰር ፕሮቴክት ለማድረግ ነው እያልን ያለው። ኦኬ አክቹዋል ኮንትሮል ያለውና ፖሰሰር መስሎ የሚታይ ሰው ሁሉ ሌጋል ፕሮቴክሽን የለውም። ኦኬ we don't give a legal protection to everybody who has a physical control over the thing. እንደዛ ከሆነ እኮ ሌባንን ፕሮቴክት ልናደርገው ነው አይደል? because he has a physical control እና ከፊዚካል ኮንትሮልም ፊዚካል ኮንትሮል አለው። that's what the law is saying. ሁሉንም ፊዚካል ኮንትሮል ሌጋል ፕሮቴክሽን አንሰጥም። ምክንያቱም there are hundreds of circumstances through which a person may come to have physical control over something. ነጥቆም ሊይዝ ይችላል አይደል? ያችንም እንደ ፊዚካል ኮንትሮል ካሰብን it's going to be nonsense, it's going to be unreasonable. ነጥቆ የያዘም ሰው እሱ እንደነጠቁት 15 ሰዎች እየመሰከሩለት ያሉ አይ ንብረት እኮ እሱ እጅ ነው ያለውና እሱ ነው ፊዚካል ኮንትሮል ያለው that is possession እኔ አልሰማም። እንደዛ አትበሉ። እኔ አይደለም ህጉ ነው እንደዛ አትበሉ እያለ ያለ። ኦኬ የሆነ ንብረት ዛሬ ጠዋት ቅድም እንዳልኩት እሱ ከ5 አመት ሁሉ ደብቆ ይዞ ከ5 አመት በኋላ ዛሬ አውጥቶ በእጁ ላይ ስላየን ብቻ he has a physical control so he is a possessor, he is a respected possessor ብለን ልንል አይገባም። if somebody else says ማን ነው 5 አመት ሙሉ አንተ ጋር እንደነበረ ማን አይቶ ያውቃል? ማንም አይቶ የሚያውቅና የሚመሰክርለት ሰው የለም። ስለዚህ the physical control you exercise over the thing should create a reasonable presumption in the mind of third parties that you are exercising the physical control. Okay? ለራስ ብቻ ሳጥን ውስጥ ቆልፈ ቁልፉን እዚህ ላይ አስረህ ስለምትዞር አይደለም ፊዚካል ኮንትሮል የሚባለው። ሌሎች ሊያዩልህ ይገባል ነው ሊመሰክሩልህ ይገባል። ኦኬ ሌሎች ሊመሰክሩልህ ይገባል። physical control should be visible, it should create a reasonable presumption in the mind of third parties that you are exercising physical control over the thing. Okay? ከሶስተኛ ወገን አንፃር ከሶስተኛ ወገን ጋር ካለ ሪሌሽንሺፕ አንፃር ነው የሚታይልህ ፊዚካል ኮንትሮል ህጋዊና ሊሰጥ ማለት ነው in order to give you the legal status of a possessor and to protect you as a possessor. We don't just look into whether you are having the thing in your hands. We also consider the intention of third parties, the presumption of third parties. What third parties think? What third parties think regarding the relationship between you and the thing? ምንድን ነው የሚያስቡት? ኦኬ አሁን እሱ ነው 3 ዓመት ሙሉ ይዞት ሲጠቀምበትና ሲመላለስበት ያየ ነው ብሎ ማለት መቻል አለባቸው ሶስተኛ ወገኖች አይደለም እንደዛ that's what 1146 article 1 together with article 2 defect የሚባለው እንግዲህ ይሄ ነው ማለት ነው it should not be secret ማለት ነው your physical control should not be secret you don't have to hide it from third parties then in that circumstance there is a defect in your physical control ማለት ነው if you hide it from third parties and if the third parties do not have the knowledge if third parties do not have the knowledge third parties ማለት እንግዲህ ማንኛውም በዚህ ሀገር ውስጥ ያለው ሰው ሁሉ ለማለት ሳይሆን ከንብረቱ ጋር some kind of relationship ያላቸው ኦኬ ጓደኞች ሊሆኑ ይችላሉ ንብረቱን ስትጠቀም የሚያዩ የመስሪያ ቤት ጓደኞች ሊሆኑ ይችላሉ or whatever ከንብረቱ ጋር ባንድም በሌላም መልኩ ንክኪ ያላቸው ሰዎች ሊኖሩና ሊያውቁልህ ይገባል otherwise your physical control will be affected by the defect of secrecy possession is secret where he who exercises actual control over the thing conceals his status as a possessor in the circumstance which justifies whom? Justifies all third parties. The assumption that he has not right in respect of the thing. Okay? እንደ ይሄ ንብረት እሱ ነበረ እንደ እሱ እጅ ነበረ እንደ አይተው ታውቃለህ አንተ እንደዚህ አይነት ሞባይል ይዘው ምናምን ምናምን ብሎ የሚባል ከሆነ your physical control doesn't have any legal protection. እሺ ማለት ነው ፊት ምንድን ነው 11 ላይ በኋላ እናያለን ሌላ ቀን በኋላ እና መብት የሚያገኘው አንዱ ባለቤቱ ንብረቱንና መብቱን ሳይጠይቅ በመኖሩ ምክንያት እሱ ደግሞ ከዚህ በኩል ፕሮሰሰር ሆኖ ከቆየ መብት የሚያገኘው ግን ከዚህ በኩል ፕሮሰሰር ሆኖ ቆይቷል ለማለት what his possession should be free from defect okay his possession should be free from defects the first defect is secrecy the second one is secrecy ግልጽ ነው አይደል ሁለተኛውን ምን ነገር ነው ወደ ሁለተኛው ከመዳችን በፊት እሺ circumstance so dubiousness ለመረዳትን you have to take two persons who claim to be a possessor with regard to the same thing okay the same thing በአንድ ንብረት ላይ ሁለት ሰዎች at the same time possessor ነን የሚሉ ከሆነና or አንድም ሰው ሊሆን ይችላል ይሄ ሰውዬ whether he is controlling for himself whether he is controlling on behalf of another person እርግጠኝነት የሚጎል ከሆነ possessor አንለውም ነው possessor አንለውም ኦኬ possessor አንለውም እርግጠኝነት የሚጎል ከሆነ ማለት ለምሳሌ ምሳሌ ሲሰጥ ወዲያው እናንተ ወደ ብዙ ነገር ትሄዳላችሁ anyways dubious possession ሊባል የሚችለው አንድ ጓደኛችን is living in Dredwa and he has a car እና የሆነ ዝግጅት or something or whatever ስላለብኝ መኪናውን ይሰጠኝና ለአምስት ቀን እዚህ ግቢ አምጥቼ ስነዳ ታያለሁ am I going to be considered as a possessor and he is also talking that he is still a possessor it's very difficult ሹፌር ለምሳሌ ሹፌር የሌላ ሰው ሹፌር እጄ መኪናው ላይ እንደዚህ አይነት እዚህ ጋር ታስራለች እንደዚህ ጥፋት ታስራለች ተብላ ያጠፋ ጥፋት የለምና አላግባብ ነው የተያዘችው ይለቀቅልኝ ብሎ ሹፌር ለምሳሌ ፍርድ ቤት ሄጄ ልክሰስ ብል ለሰማው ሰው ላይኖር ይችላል circumstance ከማጋ ነው ብሎ ነገር ታይቶ ላይሰማ ይችላል ምክንያቱም it may be difficult whether he is a possessor or whether he is possessing the thing on behalf of another person and now it has to be very much clear whether you have interest in controlling the thing it should be clear okay ስለዚህ dubiousness ወደ ምን እየሄደ ነው? is the person having an interest in controlling the thing. The second element ማለት ነው intention ለራሱ ነው ለሌላ ሰው ነው ኮንትሮል የሚያደርገው an intention to control dubiousness intention to control ጋር ከዚህ ኤሌመንት ጋር የተያያዘ ዲፌክት ነው ማለት ነው secrecy ከምን ጋር የተያያዘ ከፊዚካል ኮንትሮል ጋር የተያያዘ ነው አይደለም እንዴ ከፊዚካል ኮንትሮል ጋር የተያያዘ dubiousness ደግሞ ለራሱ ነው ወይስ ለሌላ ሰው ነው ይሄን ንብረት የሚይዘው የሚል ነገር it has to be clear. It has to be clear. So these are the two defects. And the other defect is violence. Okay, violence, although it's not clearly written. በቀጥታ ካልተጻፈ ባይጻፍም if you read 1148 ምንድነው የሚለው ሰባት ይግሏል በኃይል ከነጠቀ ሰው መልሰ መንጠቅ ትችላለህ ይላል አይደል? You can take back your possession even by using a proportional force against somebody who takes it away by force. ለምንድን ነው ከዛ ሰው መልሰ መንጠቅ ትችላለህ የተባለው? እሱ ህገወጥ ስለሆነ ነው አይደል? He is using force, he is using violence to take the physical control of the king, and the law is entitling me to challenge him. ህግ ምን መብት እየሰጠኝ ነው? ኃይል የመጠቀምና ማስመለስ መብት እየሰጠኝ ነው። ያ ማለት ኢንዳይሬክትሊ ምን ማለት ነው? እሱ ነጥቆኝ ያገኘው ፊዚካል ኮንትሮል it is affected by the defect of violence ማለት ነው። መጀመሪያውኑ ፊዚካል ኮንትሮሉን ያገኘው እሱ it is through violence. So his physical control which he has acquired on the king through violence is defective ማለት ነው. There is a defect of violence. In other legal systems it is clearly written. ቀጥታ ነው የሚጻፈው ነው. Violence, who acquires physical control over something through violence can never be a possessor. Can never be protected as a possessor. ብሎ ነው እኛ ሀገር ግን indirectly ነው መስላ 11% So there are other defects also. You read from the material as well as from there are other defects. And now what are the protections available to a possessor? የምንለውን ነገር አይተን ወደ ኦነርሺፕ እንገባለን የሚቀጥለው ክላስ. I think it's enough for